Welcome to the Lex Islamica video course series brought to you by the Advanced Legal Studies Institute, Islamabad. This video is part of the Miscellaneous series, which will contain videos related to various topics that are not a part of an organized course. If this topic requires additional videos in the future, we will make a separate playlist to keep things organized. This video, Presidential System for Pakistan, highlights how the parliamentary system has failed in Pakistan and then provides a structure for the solution, which is the presidential system. Let's begin. This video begins by understanding the form in which the British parliamentary system has been implemented in Pakistan. As Pakistan has a written constitution, while the UK has no constitution or an unwritten constitution, there are bound to be major differences between the two systems. The first point to understand is that the British parliamentary system has failed in Pakistan, and to understand why it has failed. A major reason for this failure is that the parliamentarians, including some of the senior parliamentarians, do not understand how the Pakistani system is different from the British system. This has led to serious distortions in the idea they have of their own parliament. For example, they do not understand what the phrase parliamentary sovereignty means in Pakistan. They also do not understand the meaning of the phrase supremacy of parliament in the context of Pakistan. A brief example of just these 2 points shows that the parliamentarians are quite confused about the system they are practicing. The result is that they have lost interest in legislation, which is the primary function of the parliament, and have assumed a role for themselves that really belongs to local government. Consequently, the parliamentarians are constantly in search for development funds with which they can strengthen their own positions in their constituencies. After identifying the defects from which the parliamentary system, as implemented in Pakistan, suffers, the video turns to the necessity of implementing the presidential system in Pakistan. After examining these issues, it becomes evident as to why Pakistan needs to move from the hybrid parliamentary system that it has implemented to a presidential system that is more suited to the needs of this country. The video then deals with the broad features of the presidential system that can and should be implemented in Pakistan. The first proposal deals with the president and the executive of which he will be a part. This is followed by the structure of the legislature and the clear identification of its function. The election of the president and of the two houses proposed in the previous topic are dealt with after that. In this, the duration for which the president is to be elected is of particular interest. The judicial system of Pakistan functions on an adversarial basis following the British judicial system. In the proposals dealing with the judicial system, an inquisitorial system has been proposed for the lower courts. The role of the lawyers will be minimal at the lower level. However, they will have a greater role to play in all the appellate stages. The final topic deals with the institution of zakat and how it is to be related to the system of taxation. The distribution of revenues collected by the Federation among the provinces has also been given some attention. This will bring us to the end of the video, in which we have focused on the major features and discussion of the details has been avoided. Future videos may take up individual sections of the system in more detail. The British parliamentary system has failed in Pakistan. The British parliamentary system, or its hybrid form that has been implemented in Pakistan, has failed and has collapsed. Most of the parliamentarians, even when they have professional qualifications in law, do not understand how the British system or its traditions and conventions work, or even how their system is different from the one prevalent in the UK. One reason why they don't understand these is because the traditions and conventions are a part of the constitutional history of the UK. The history is based on a prolonged struggle in which the people had to resort to violence to secure their rights. The result was that the House of Commons, which was a body representing the masses, came to have a dominant position in the system, and the position of the monarch was reduced to that of a rubber stamp. The people of Pakistan have not undertaken such a struggle for their parliament, and many are not even aware of their rights. It is for this reason that they do not understand and appreciate the value of these traditions and conventions. The parliamentarians, it appears, have forgotten why the parliament exists and what its main purpose is. In the last decade or more, there has rarely been any meaningful debate about proposed legislation. Legislation has become a secondary function of the parliament, and even when these acts are passed, They are often rushed through the Parliament without proper debate and analysis of the provisions. It also seems that the parliamentarians have come to believe that their task is to secure their own perks and privileges and to seek development funds that they can control in their constituencies. The majority of the voters think that they are voting for assembly members who will come back when elected to take care of their sanitation, sewerage, pavements, and jobs. In short, the system is in a mess. The reason why the people want these members to take care of their local problems instead of focusing on legislation is that the local government systems are either not implemented or they are paralyzed when they are implemented. Many erroneously believe Parliament is supreme. Some of the senior parliamentarians who received their education in the early days believe and proclaim that the Parliament is sovereign and supreme. The younger parliamentarians repeat this statement without having any idea of its meaning. The statement is absolutely incorrect as far as Pakistan is concerned. It confirms that our parliamentarians neither understand the British system nor do they understand our own. We will analyze it first from the perspective of sovereignty of the Parliament. The UK has no constitution while Pakistan has a written constitution. It is essential to understand this fundamental difference between the two systems. The UK has no constitution because some of its constitutional provisions are spread over around 400 statutes. These statutes are just statutes and are not superior to other statutes. In Pakistan, there is a written constitution which is superior and prior to all statutes. The written constitution establishes a hierarchy of the sources of law in which the constitution is superior to the statutes. This point about the hierarchy is very important because the parliamentarians and the legal fraternity in Pakistan fail to understand its meaning because the hierarchy does not exist in the United Kingdom, there being no written constitution. Is the Parliament sovereign? Sovereignty of Parliament in Pakistan. Sovereignty means power that is absolute and uncontrolled. When a power is subject to the control of some power superior and external to itself, then such power is not sovereign. Sovereignty of Parliament means that it can make any law whatsoever without any kind of restriction. It is in this sense that it is said, Parliament can turn a man into a woman and a woman into a man. This saying applies to the British Constitution. Pakistan is a republic and a democracy, and it is an Islamic republic. Being a republic means that there are certain fundamental laws that democracy cannot do away with. This point distinguishes a republic from a pure democracy. In a pure democracy, in exercise of the will of the people, the Parliament may turn a man into a woman and a woman into a man, but not in a republic. In a republic, some fundamental laws cannot be upset by the will of the people. In the case of Pakistan, the Parliament cannot make laws that go against the legal provisions of the Quran and the Sunnah. In other words, Parliament cannot make laws that are repugnant to Islamic law. To this extent, the Parliament is not sovereign and its power stands restricted. Here it is to be remembered that Pakistan is an Islamic republic and the fundamental laws we have talked about above are the injunctions of the Quran and the Sunnah. Is the Parliament sovereign? Continued. Article 8.2 states, "The state shall not make any law which takes away or abridges the rights so conferred, and any law made in contravention of this clause shall, to the extent of such contravention, be void." The power of the Parliament has been restricted here. It is not sovereign. This article is talking about the fundamental rights identified in the Constitution. The Constitution does not allow the making of laws that go against these fundamental rights. As an example, note that Article 25(1) that deals with the equality of citizens says, "All citizens are equal before law and are entitled to equal protection of law." If certain citizens get together and make a group called LGB, lesbians, gays, and bisexuals, they then demand that the Parliament make laws for the equal protection of their group rights. The Parliament is not free to make such laws and is not sovereign. This is a complex example because saying that no law can be made favoring the LGB group contravenes the fundamental right of equality of citizens. Accordingly, this statement cannot be made. On the contrary, granting rights to this group will be un-Islamic. Please note we have avoided using the term LGBTQ intentionally. If the Parliament makes a law that clashes with a provision of the Constitution, the higher courts can strike down such a law. To this extent, the Parliament is not sovereign Rather, it is the Constitution that is sovereign. We shall elaborate this point in the next slide. Supremacy of Parliament and Pakistan. Slide 1. Supremacy of Parliament and the UK. Supremacy of Parliament means that the laws made by Parliament cannot be questioned by anyone, whether it is the superior judiciary or any other authority. The courts have to implement the law as far as possible with the help of the canons of construction. Where a statute becomes impossible to implement except by amendment of the law, the only option open to the judiciary is to send it back to the Parliament. The Parliament may then amend the law or make a new law as it wishes. Hierarchy of legal texts in the UK and USA. In the USA, there is a written constitution, therefore there is a hierarchy of texts. Thus, Justice Cardozo said, the Constitution overrides a statute, but a statute, if consistent with the Constitution, overrides the law of judges. In this sense, judge-made law is secondary and subordinate to the law that is made by legislators. In the UK, there is no hierarchy of the texts or laws. Indeed, there cannot be, because the UK does not have a constitution. How can the Constitution override the statute when there is no constitution? Separation of powers in the UK and USA. In the United States, there is separation of powers, which may not be perfect, but it does exist to a great extent. In the UK, there is no separation of powers. Up until recently, judges of the highest court used to sit in the House of Lords as well. They were called the Law Lords. A statement of the judges is well known as a quotation. We sit here as servants of the Queen and the Legislature. The doctrine of separation of powers has been upheld by many thinkers like Locke and Montesquieu, who maintain that the three organs of government, namely the legislature, the executive, and the judiciary, must be independent of each other. A system of checks and balances should be implemented so that power can be checked with power. In the UK, there is no separation of powers. In the USA, the judiciary is completely independent of the other two organs of government. The executive under the president is also independent of the other two organs, namely the legislature and the judiciary. In the UK, the executive is part of the legislature in the form of ministers. The executive is not only answerable to the legislature, it is also accountable to it through its committees. In short, the system of checks and balances, where power is checked with power, is only available through separation of powers. It is not available in the UK because all three organs are in fact one, with the Parliament being supreme. How can a single power check its own powers, especially when one organ is supreme within the grouping of three? We can understand this through the system of judicial review. Judicial review in the UK and USA. There are two types of judicial review in the USA: judicial review of statutes and judicial review of administrative action. In the UK, there is no judicial review of statutes. The judiciary in the UK can only send back the statute when it cannot be implemented. However, it can never say that a statute is unconstitutional. First, there is no constitution against which the constitutionality can be judged. Second, the courts do not have the authority to question acts of Parliament because the Parliament is supreme. Applying the supremacy doctrine to Pakistan. After the above description, it will be easy to see what kind of a system we have in Pakistan. First, Pakistan has a written constitution like the USA and unlike the UK. There is thus a hierarchy of texts. The constitution is at the top and it will override the statute, which will override the rules and the judge-made law. This hierarchy has been rendered fuzzy by phrases like subject to law used in the Constitution. The phrase subject to law has been used in the Constitution, especially in definitions of fundamental rights. The phrase amounts to putting a dent in the right being defined. This disturbs the hierarchy by diluting the strength of the article. Second, as there is a hierarchy of texts, it is possible to judge a statute in the light of the Constitution so as to judge its constitutionality. Pakistan thus has two types of judicial review like the USA: review of statutes and review of administrative action. Parliament is not supreme as far as judicial review of statutes is concerned. This is so because the judiciary can restrict its absolute power of lawmaking. Third, The executive, however, does not enjoy independence, as ministers who are members of the Parliament direct the actions of the executive to a great extent. In this case, Parliament does not enjoy some kind of supremacy over the executive. This supremacy is somewhat muddled due to the rules of business, perhaps due to the assumption that the minister will know very little about running a ministry. We shall have more to say about this later. Fourth, we have already seen under the topic of sovereignty how the law-making powers of the Parliament of Pakistan are restricted. This too is a kind of demolition of the supremacy of the Parliament. Finally, the power of the Parliament to appoint judges of the superior courts has been eliminated, and the Parliament does not have the power to impeach the judges and to remove them. The analysis shows that we have created a system that is neither here nor there. Tremendous power has been granted to the judiciary without the possibility of external checks like appointment and impeachment. A situation has been created where there is a constant tussle between the bureaucracy and the ministers. The Parliament feels powerless as the checks granted to it in other constitutions have been taken away. Due to the muddled situation, the judiciary sometimes deals with political questions and crosses over into the realm of policy, which is the domain of the executive. Most parliaments or legislatures, in order to check the power of the judiciary, have been granted the power of appointing judges and the power of removing them through impeachment. In Pakistan, the Supreme Court performs both these functions. Therefore, the supremacy of the Parliament is a glaring fiction. Presidential system is the need of the times. Two offices are inefficient and wasteful. In the United Kingdom, the monarchy as represented by the Crown is an institution that has been maintained for centuries. It is deemed essential by the UK for reasons we need not recount here. Due to the necessity of depriving the monarch of many powers, the institution of Prime Minister was gradually devised. In Pakistan, the office of the President is supposed to mirror the Crown, but it is an unnecessary and highly expensive institution, especially when the President enjoys no powers. The solution is to eliminate the office of PM and to give all the powers to the President. The rule of a single person has been historically compatible with our society. Historically, too, there has always been a single individual who has been held responsible and has been granted all the authority. This has been true whether the office was that of the Khalifa or the Sultan. Our people are more favorably inclined towards the rule of a single individual. Majority of our members are not trained to be ministers. In the United Kingdom, the parties implement the system of shadow governments. Members of such shadow cabinets are ready to take over as ministers if the party comes into power. Such ministers are fully trained and have become experts in their areas of specialization. In the last 50 years, Pakistan has not been able to develop such a system. The probable reason is that our parties are too unstable for developing this system. The result is that ministers are usually inexperienced, being unable to run their ministries, which leads to a wasteful merry-go-round. This is a luxury the country can no longer afford. Pakistan needs highly trained experts to be appointed as ministers. This is possible only in the presidential form of government. Members should focus on legislation alone. Members of both houses, especially the lower house, must focus on legislation to secure the rights of the masses. The race for ministerial posts or the efforts for securing development funds is not only contrary to the objectives of lawmaking, but is not the function of these legislators. This is one reason why the local government system has not been allowed to function. The independence of the executive must be restored so that it can perform its true role. There are two problems that affect the executive. The first is that a member of the legislature becomes the leader of the ministry and the executive has to follow his directions, even if he does not understand how the departments operate. The second problem is that if a political party remains in power for 2 or more terms, it employs persons that are or will become loyal to this party. This army of loyalists become the executive and can create huge problems for the government of another party simply by slowing down operations. The present government has complained many times of this problem. There is a fake propaganda by vested interests that the parliamentary system ensures the continuity of the federation. 1. 80% of the countries of the world follow the presidential system, and many of these are federations, including the USA. 2. Names of provinces do not mean that the provinces belong to the ethnic minorities associated with such name. Today, the population makeup in the provinces has nothing to do with their names. 3. If the province of Punjab can be divided into 3 or 4 smaller units, so can every other province. 4. At the time of the breakup of Pakistan in 1971, the system was not a true presidential system but a dictatorship. The survival of governments, especially those with thin majorities, is at the mercy of powerful groups. Over the years, business interests have come to align themselves with political interests. This has been possible because many politicians have set up large factories to become capitalists. In addition to the above, many businessmen have turned into politicians. They have been able, by using or misusing their political power, to expand their business networks to dominate economic and industrial activity within the country. Business interests indulge in lobbying to influence government policies and presidential systems too, but in Pakistan, certain developments have taken place that may be irreversible unless the system itself is changed. 1. Contesting elections is like a business. Huge sums are invested to win elections in the hope of becoming ministers or gaining other offices to recover their investments. 2. It has become a practice to buy the vote of members for electing senators, who will then promote their personal interests. And 3. Governments with thin majorities or those based on coalitions are always under threat from powerful interests. In a presidential system, if members are bought this way, at least the government will not collapse. The President and the Executive. We now begin with a few simple proposals for implementing the presidential system in Pakistan. The first such proposal is about the President and the Executive. The people will elect a president for 7 years. He will be at least 40 years of age and will be a Muslim male. There will be no vice president. If the president dies, the Chief Justice will take over for 3 months to conduct new elections. The president to be elected may or may not belong to a political party. Parties will devise their own system for choosing a person to be nominated for being elected as president. The president will be elected through a system of direct elections. He can serve for 1 term alone and cannot be elected again ever. The American president is usually elected for 2 terms. Pakistan cannot afford expensive elections. 7 years are likely to give stability to the system and provide an opportunity to a dedicated individual to make a significant contribution to the national interest. The president may be impeached by the legislature for breach of the trust reposed in him. None of his close relatives will be eligible for being elected president in the term immediately following his term, nor will the president induct any of his close relatives into the executive. He would not have the power to issue ordinances whether or not the legislature is in session. Lawmaking must always be the prerogative of the legislature. The president shall have full and unhindered executive powers. He will appoint the Chief Justices and the heads of all major agencies and public sector organizations. He will appoint the chiefs of the armed forces. Appointments of Chief Justices, judges of the Supreme Court, heads of agencies and public sector organizations are to be confirmed by the legislature. The President will make all career appointments, but the cabinet and civil service appointments will be based on a system like the American spoils system. See the American Plum Book. Thus, he will choose his own cabinet and will have the authority to choose anyone other than a close relative as a minister. Appointments of experts who will come with the president and leave with him after 7 years to be replaced by those of the new incoming president. The minister will also be the secretary of the ministry and the principal accounting officer or the chief operating officer. Besides the minister or secretary, all advisors, additional secretaries, joint secretaries, and deputy secretaries will be appointed by the new president. They will move in with the president and leave with him, vacating their offices for the appointees of the next president. Section officers will be career officers to be recruited in the regular existing method. This method will ensure that the team working as the executive will fully support the president on whom their appointments depend. It will also ensure the appointment of suitable experts where they are needed. There are many other advantages too. The transition period where the team of the new president has to take over from that of the earlier president will be modeled after the American system with suitable adjustments. Legislature and its functions. The lower and upper houses will consist of directly elected representatives. Both houses will be elected for a period of 5 years. Their election will have nothing to do with the election of the president. The lower house will make all laws. It will approve all taxes and sanction the annual budget. It will have special committees for holding hearings where confirmation of appointments made by the President is required. It will have monitoring committees for the work of ministers and the executive. The upper house will provide guidance to the lower house from the Islamic perspective and other technical perspectives by sending back bills to the lower house with comments where necessary. The upper house will monitor the work of the public sector organizations. The Council of Islamic Ideology will be abolished. The committee to which a bill is referred must invite witnesses to testify about the legislation, inviting written comments from others. Except for the finance bill, every bill must be introduced by a member of the lower house, that is, as private bills. Each bill must be accompanied by a research report on the issues incorporated in the bill, for which purpose the member may seek the help of private legislative bureaus, if the Pakistan Institute of Parliamentary Affairs fails to deliver. The constitution of the country will be amended by 2/3 majority of both houses, and the amendment to be effective must be ratified by a simple majority of each provincial legislature. No development or other such funds are ever to be provided to the members of the lower or the upper house, nor will they interfere with the development and administration of their local constituencies. Members of the lower house will preferably have knowledge of the Islamic methodology of Maqasid al-Sharia, but such knowledge will be mandatory for members of the upper house. Elections of President and both houses. The President is to be elected by the entire vote of the public eligible for voting. Everyone who is 18 or above will be eligible to vote. The President must be a declared Muslim. No other qualification is required, but he must not have been convicted by a court of law for moral turpitude. Every member of the legislature must be 25 years old or more, and must not have been convicted by a court of law for moral turpitude. Every tehsil shall have one member for the lower house, and every district shall have one member for the upper house, where the members shall be elected by the eligible vote of the public in such district or tehsil. Population of the tehsil or of the district is not to be taken into account. The Federation may limit the number of tehsils and districts according to a criterion set by the legislature. 20% of tehsils in each province will be reserved for the direct election of women candidates every term. A system of rotation will be adopted with the women seats moving to the next 20% in the next term. This provision of affirmative action for women may be dropped once they have been fully absorbed into the political system, as in many developed countries. Nevertheless, even through this system, they must contest elections and not be given seats for other considerations. Elections to the legislature will be held every 5 years on a day that is fixed once and for all, like a Wednesday of the second week of a particular month. This should be automatic, and the people should know beforehand when elections will be held. Further, there is no need of interim governments for holding elections. Individuals can be elected to the houses for a maximum of 3 terms, irrespective of the house to which they are elected. The judicial system. A civil judge cum judicial magistrate, to be called the Ilaka Qazi, will be housed next to each thana or police station. The jurisdiction of this Ilaka Qazi will extend to the jurisdiction of the thana, while pecuniary jurisdiction will be the same as that of an existing civil judge. The Ilaka Qazi will try all criminal cases including murder. The process at this court will be inquisitorial and not adversarial, and the judge will record all complaints in his own hand based on petition by the citizen or based on a police report. All criminal investigations will be undertaken with the help of the attached thana, and the Ilaka Qazi will also monitor the police station. All cases will be decided within a period of 3 months. No lawyers will be required to appear in this court. The Ilaka Qazi will be a judicial officer of 5 years standing who has worked as an assistant to the Ilaka Qazi or worked at other courts after his selection for the judicial service. Appeals from the court of the Ilaka Qazi will lie to the district court, and from there to the divisional court, and finally to the high court of the province. The proceedings at these appellate courts will be adversarial, and lawyers trained in the methodology of the Maqasid al-Sharia will play their full role. The Supreme Court will hear constitutional cases, including those of human rights. It will also hear matters concerning intra-provincial issues. The Federal Shariat Court is to be abolished, and the Supreme Court as well as the High Courts will decide all Islamic issues. All judges and lawyers must take a comprehensive bar examination after obtaining their professional qualifications. All judges, in order to be eligible for any judicial office, must be thoroughly trained in the Islamic methodology of the Maqasid al-Sharia. Miscellaneous Proposals. A few proposals regarding zakat and taxation may also be considered. The nisab of zakat is to be based on gold and not silver as far as the beneficiary is concerned, so that up to 7.5 tolas can be given to a poor individual in 1 year. The nisab for payments on other items, including fiat money, should also be based on gold and not silver. If someone has silver, he should pay for the silver on the basis of 52 tolas, but not for other things. Zakat will be given freely to anyone who asks for it. Beneficiary liars, when discovered, will be awarded 10 years rigorous imprisonment. Compulsory zakat returns will be filed with the FBR. Assessee liars are to be awarded 5 years rigorous imprisonment. Zakat officials embezzling zakat funds are to be awarded 14 years rigorous imprisonment. When zakat is paid by an individual directly to a beneficiary, verified supporting documents are to be attached with the return. All persons will be liable for zakat. The term person will include legal persons. Assets will include gold and silver 2.5%, rental income 2.5%, business working capital including inventory is 2.5%, produce of land 10 and 5%, minerals including petroleum 20% when extracted. All data provided for zakat will form the basis of taxation. A person who pays zakat will also be liable for taxes, that is, income tax. All taxes will first be approved by the lower house of the Majlis-e-Shura, announced publicly, and only then included in the taxation system. The President is not to issue ordinances for levying taxes. All income tax returns are to be filed with zakat returns. The federal divisible pool is to be divided equally among the provinces so that large provinces are forced to divide themselves into 2 or more if they wish to benefit from this award. The federation may prevent excessive division just as it may prevent the creation of additional tahsils and districts. Thank you.